Welcome, everyone, once again to day 2 of our Supreme Court week. I am your anchor and host, Mr. Brian Keith Jackson. Off to my left, I have my esteemed colleague over here, Ms. Maggie Berthune, and to my right, another esteemed colleague, Mr. Bill Batterman. Today is going to be a little bit of a treat. It's going to be very interesting today here at WA Live Court TV edition. What you're about to see is as follows. The Supreme Court will give their verdicts on the 2 cases that you all heard yesterday. We will then immediately process into the next 2 cases you're going to hear today, which are 2 drug dog sniffing cases, Florida versus Jardines, followed by Florida versus Harris. So, counselors, let's talk about these 2 cases that you're about to hear. All right, now, both these cases occur in Florida. Both these cases concern drug dog sniffing. All right, handicap the case for us. Mr. Batterman, we'll start with you first. What do you think is going to occur today?
Well, both of the cases involve the legitimacy of particular kinds of drug sniffing dog searches, which the Supreme Court has held 3 times, do not constitute searches under the Fourth Amendment. The most notable case being United States v. Place in 1983. It seems unlikely to me that the court will decide that drug sniffing dogs do constitute a search, which puts the odds of Florida winning the Harris decision pretty high. But the Florida v. Jardines case might be a different story, because even though it's a drug sniffing dog case, it's also a case about the sanctity of an individual's home and the increased level of privacy expectation that individuals have in a house as opposed to a car or an airport. So I think that Florida might be in more trouble in that case. So if I was handicapping it now, I would say Florida wins in Florida v. Harris, Jardines wins in Florida v. Jardines.
All right, Ms. Berthune, you heard Counselor Batterman's arguments. What is your perspective?
I agree with that assessment. I think that the Supreme Court, even the more conservative justices, have long been in favor of the sanctity of the home, and so have been hesitant to allow searches there that they freely allow elsewhere. And so I think in Jardines, Mr. Jardines has a very good chance of prevailing. In Florida v. Harris, it's a tougher issue. The court has ruled in previous occasions, most recently in 2005, that drug sniffing dogs, even in traffic stops, do not constitute searches. So training will be at issue today, but I think the state of Florida has a pretty good chance.
All right, very good. Thank you for that handicap. All right, now, ladies and gentlemen, we actually have a special treat or something different that sort of like came up today. For the second case you're going to hear, which is going to be Florida versus Harris, we're actually going to have 2 of the WA Live commentators who are actually going to guest speak, and they're going to argue the case before the Supreme Court. We hope you enjoy this particular broadcast and you learn something along the way. I think I hear now that the Supreme Court is now ready to proceed, and we're going to get the verdicts for the cases we heard yesterday, and then we'll proceed directly into the 2 cases we're about to hear today. Thank you very much for watching Woodward, a WA Live Court TV edition. Turn it back to the courtroom.
All rise. The United States Supreme Court is now back in session. The Honorable U.S. Supreme Court Justice is presiding.
May be seated. The court would like to announce decisions that we've made on 2 cases that we heard yesterday. The first case, Justice Sotomayor?
Evans versus Michigan.
Evans versus Michigan. This was the case regarding double jeopardy. The Supreme Court has ruled unanimously 9-0 in favor of and that it's not double jeopardy. Second case, Justice Sotomayor. Bailiff, I need some help here. Bailey versus the United States. The court has ruled a 5-4 decision in favor of the United States. So be it.
The United States Supreme Court is now in session. The Honorable United States Supreme Court Justice is presiding. The two cases on the docket today are Florida versus Jardines and Florida versus Harris.
Is the counsel ready for the plaintiff in Jardines? Is the defendant? Yes, Your Honor. Thank you. Then plaintiff, you may approach the podium.
I am Ben Marcus, and I am representing the state of Florida. On December 6, 2006, on November 3rd, 2006, police received...
which is it?
Sorry, November 3rd. Police received a phone call, an anonymous tip, saying that Jolis Jardines was in the production of marijuana in his home. How does one produce marijuana? It is grown. It is a plant.
Okay. So it was organic, not synthetic.
Correct.
Okay.
On December 6, 2006, police officers staked out the home.
I thought you said November.
That was when the phone call was received.
Got it.
They watched the home, and when Jolis Jardines approached...
I'm sorry, was there a search warrant obtained to watch the
premises? They were on public property.
Was the tip taken to court to be proven as an accurate tip?
They were doing surveillance to see if it was accurate. When Jolis Jardines, they approached the home to confront him because Officer William Pedra, an experienced Miami-Dade police officer, saw many of signs of drug production, such as the wall unit on for 15 minutes continuously.
What wall unit? The air conditioner?
Yes, ma'am.
The heating and cooling?
Yes. For 15 minutes continuously because that is common.
What was the temperature that day?
I'm guessing about warmish, but not super. That's a common sign of drug production because the lights that grow them get extremely warm. They also...
In what type of climate is marijuana grown?
Very warm.
So was this wall unit, was it running on cool or hot?
Cool, to cool the lights.
What if it was just a hot day?
There are other signs that it was a drug production.
Such as?
The officer, as he approached the home, smelled marijuana. He also had a police dog with him who also sensed marijuana and alerted the officer immediately.
How was the dog trained?
He had been through many, many weeks of continuous service.
What breed of dog was this?
I do not know.
So if the officer smelled marijuana already, why did he need a dog?
The dog was around for protection also.
So what is it, a search dog or a protection dog?
A search dog, but he also...
What is the certification for that?
Training by the state of Florida.
What was the dog trained for?
To detect many types of drugs, including marijuana.
What did the dog do to signal that drugs were near or in the vicinity?
He started walking around and sitting, which was the command to...
Had the dog urinated yet?
That is unknown. The dog's alerts have been very good, well received over the past couple of years of his service. He's found over 13,008 grams of cocaine, 2,638 grams of heroin, and 180 grams of methamphetamine.
How much marijuana? How much cannabis?
In past, he had found 936,614 grams of marijuana.
So would you then say the dog was an expert more
Yes.
at heroin than with cannabis?
He was best with marijuana. He also, they later returned with a search warrant to enter the home. because of they had probable cause that there was marijuana on the property.
Was the probable cause, like, did they know that on the public property or on the private property of the house?
On the front lawn of the home.
So they smelled the marijuana when they were on the front lawn of the home?
That is correct.
How close to the front door?
Porch.
On the porch?
Yes, ma'am.
Without a warrant? With a search dog?
It is the home in question. A warrant should only be required for a home because a sniff is not a search under the Fourth Amendment. There have been 3 previous rulings that coincide with this: United States versus Place, City of Indianapolis versus Edmond, and Illinois versus Cabells.
Did they enter the home at all when they did not have a warrant?
No, they did not.
So they were only on the outside of the home?
That is correct. The dog was sniffing free air.
How did they know it wasn't the neighbor?
The phone call was the reason they were surveillance, and many things that led to it, and the dog's expertise. Cause he wouldn't have been able to smell unless he was his expertise led them to smell when he was close, and the officer also smelled drugs at the home.
Was the anonymous tip that the officers received, was it verified?
That's what the surveillance was the surveillance was to verify whether or not the tip was probable cause for a search.
You may proceed.
After the dog sniffed the air, after the dog alerted that there was marijuana, and the officer also confirmed himself that there was marijuana by smelling, they received a search warrant and returned later that day and searched the home legally and found marijuana.
Was it a grow house?
It was a grow house.
Did they have furniture in there?
Unknown.
Did they have a bed?
Unknown.
How many rooms was it used for a search house? For a grow house?
Again, unknown. It was the home of Mr. Jardines.
Did it have a commercial sprinkler system installed?
Unknown again.
Was there food in the kitchen?
Unknown, but
was there a refrigerator?
Again,
were they paying taxes on this house?
No, but they were not paying the electric bill. He was also convicted. Mr. Jardines was also convicted of stealing, I think, $15,000
from Florida Power and Light.
Yes. And
how was he stealing the electricity?
Unknown.
But you know that he was stealing electricity?
Yes, that was confirmed.
And he owns this property?
Yes, he did.
Free and clear with title? Free and clear with title? Or is there a mortgage on this property?
Again, unknown.
Was someone living on the house permanently? Was it like
he was? Yes, that was his residence.
But with no bed.
I do not have information. It is likely that he was a bed because it was his residence.
How do you know he was living there then?
Because it was confirmed as his residence by witnesses and neighbors.
Did he confirm it as his residence?
He called it his home, yes, in previous proceedings.
Okay. Was he in the house at the time the police searched?
When they saw him enter the home, that they knocked on the door and confronted him.
Okay. Did he submit when the confrontation?
He did not let them in his home, but he didn't force them off.
So was there violence?
No. Are there any other questions?
Okay, thank you.
Thank you.
Is the counsel for defense ready? You may approach the podium, please.
Hello, my name is Rushal Chandra, and I will be representing Joelis Jardines. My client's Fourth Amendment rights were violated on November 3rd, 2006, when Detective William Pedraja and his canine Frankie had trespassed onto his property warrantless. This is considered an unlawful entry. The Fourth Amendment states that the citizens of the U.S. are protected from any unnecessary search and seizures that are not accompanied by a warrant. Detective Pedraja and Frankie had clearly violated this amendment. The detective and Frankie trespassed onto the property, and Frankie began sniffing when Joel Jardines was not at his residence at the time. Additionally, my client argues that the method may lead to indiscriminate and discriminatory searches of homes. Frankie had also apparently sniffed what was claimed as drugs. Recent research by the Rutherford Institute shows that a dog's accuracy in smelling drugs is only 15%, while the other 85% are only false alarms. So this claim, once again, is inaccurate. In conclusion, Jardines would like the court to rule that the search is unconstitutional and to suppress all evidence that was obtained from this illegal search.
You said that many dog sniffs are inaccurate.
Yes, recent research shows that only 85% of the time they've been false alarms.
But wasn't marijuana proved to be in the house?
Later, after the officer got a warrant.
So the dog sniff was right.
It wasn't claimed until a month later.
What wasn't claimed?
It wasn't claimed that the man was producing drugs until a month later when Officer Pedraja got a legal warrant to search the house.
But was it not the signal from the dog that allowed the police officers to get the warrant? So
No,
wouldn't
at
his
that-
sniff have been correct?
Now, at that time, it was not told for because many dogs' false alarms have also been from household items. Many of the chemicals used to produce marijuana are also found in household material,
Such as?
such as home grease, table cleaners, stuff like that. Some of the same chemicals have been apparently used in marijuana.
What specific chemical?
That is on it.
But is the dog trained to smell these chemicals or marijuana?
Both.
So you mean the dog is trained to smell the chemicals in marijuana and not marijuana specifically?
No. The dog is, well, actually, frankly, yes.
Were the household items present in the house?
That is unknown.
So the dogs are trained to smell chemicals in household cleaning products and marijuana?
Yes.
So you're saying he mistaken the smell of marijuana for the cleaning materials that were not in the house?
No, they were in the house.
You just said they weren't.
The cleaning materials were in
Yeah,
the
they
house.
were,
They were
in the house. Yes.
So if he was trained to smell both, wouldn't he be able to tell the difference?
No, he would have been confused because the chemicals are the same.
So do you believe the police officer and the dog, Frankie, were trespassing on Jardine's property?
Yeah, because at the time he didn't have a warrant, and he was on the porch, which is still his private property.
Any further questions? How much of a given chemical would the dog have to have in order for him to smell it? Like what percentage? Or
That is unknown.
how many particulates? Or
That is unknown.
okay. Any other questions? We're done. Thank you. Would you like a rebuttal, sir?
Yes.
Go. Please approach the podium.
The proof that dog sniffs have been mistaken for household cleaning items is only in marijuana. The items he talked about are in marijuana and not dogs trained to detect cocaine are actually trained to detect methylbenzoate, a decomposition product that is produced when cocaine is exposed to humid air, also found in many types of flowers, perfume, and food additives. Dogs trained to detect heroin are actually trained to detect acetic acid, which is present in vinegar, aspirin, food additives, and green or earthly friendly household cleaning supplies. None of those things are in none of those represent marijuana.
Does the age of the dog affect how well they can sniff drugs?
If they're extremely old, but Frankie, I have that information, but I do not think he's that old.
All right. Thank you.
Thank you.
Is the attorney for the plaintiff ready?
Yes, ma'am.
Is the plaintiff for the defense ready?
Yes, Your Honor. That's ready.
Okay, then please approach the podium and present your case, ma'am.
I'm Maggie Berthium, representing the state of Florida. The facts in this case are not at issue. Clayton Harris was arrested for the production of methamphetamines that were found during a routine traffic stop. During that traffic stop, Mr. Harris was shaking and breathing rapidly, so the police officer used Aldo, a trained drug detection dog, to search the vehicle where the drugs were found. The Florida Supreme Court ruled the search was illegal because Aldo had not specifically been trained to detect methamphetamines. The issue before you today is whether the onerous training and records burdens required by the state of Florida should stand. We contend that they should not. You have ruled 3 times as a Supreme Court body that drug detection by dogs is not even covered by the Fourth Amendment. By its nature, a Fourth Amendment search is used to sort between legal and illegal material. Because the dog can only detect illegal material, it is simply not a search. We ask you to overturn the Florida Supreme Court ruling and rule that the alert from a trained police dog is sufficient evidence to give probable cause for a search. Moreover, precedent strongly indicates that trained dogs are the most reliable and least intrusive means available to the police. In 1983, in United States v. Place, you ruled that the use of a drug-sniffing dog is not a Fourth Amendment search. You upheld this ruling in 2005 in Illinois v. Caballes, clarifying that during even a routine traffic stop, the use of a drug detection dog is both legal and not a Fourth Amendment search. Because they are efficient and do not involve touching the person or vehicle, drug-sniffing dogs are the least intrusive means available to the police. Any determination by this court which deters police forces from employing these dogs will only lead to searches which have a greater burden on the suspect. Harris's lawyers are going to contend that Aldo made a false alert in this case. However, the Fourth Amendment does not require absolute certainty, so even if you determine he was wrong in this case, it does not mean that you should rule out police dogs in general. Police officers need only a reasonable belief that a crime has occurred, which existed in this case. In addition, there's just no evidence that Aldo made a false alert. The Attorney General of Florida put it best. When you enter the kitchen and smell popcorn, the fact that someone has already eaten all the popcorn and put the bag outside in the trash takes nothing away from the fact that you accurately smelled popcorn. Aldo sniffed the vehicle and smelled marijuana. It is unduly burdensome, indeed impossible, to require dogs to differentiate between current illegal substances and the residue of those substances.
How much marijuana was found?
No marijuana was found. The ingredients for a substantial methamphetamine lab were found in the vehicle.
So ingredients to make drugs were found in the vehicle?
Yes, sir. If Mr. Harris did not have drugs in his vehicle, a quick search would have sent him on his way. We are only here because Mr. Harris did, in fact, possess illegal material. Harris's lawyers will also contend that it's very easy for the police to keep field records on their dogs. However, field records are not only difficult to obtain, they actually reduce our understanding of the success rates of the dogs. They cannot be used to determine whether a dog is accurate. If a dog alerts in the field in a real situation and drugs are not found, it doesn't mean the dog was wrong. It means the drugs were not present at the time, but may have been only moments before.
Aren't you innocent until proven guilty in the court of law? Isn't that the whole foundation of our judicial system?
Yes, ma'am.
Does not a dog then take away that person's right to have a trial?
Innocent until proven guilty applies in the court of law. In instituting a search, the police need only a reasonable belief that a crime has occurred, not beyond reasonable doubt.
What was this reasonable belief?
The reasonable belief in this case is that Aldo indicated that drugs were present at the scene.
So this was just a routine check? It's just random?
Yes, sir. He was checked. He had expired license tabs. He was pulled over for that and was breathing heavily and appeared to be under the influence of drugs, so Aldo was used.
Could he not have had a heart problem, perhaps, Madame?
Yes, which is why Aldo was used to determine whether drugs were present. If drugs had not been present, Aldo would not have alerted, and thus Mr. Harris would have been released. However, Mr. Harris was not innocent.
Mr. Harris not have had the flu and was taking medication to alleviate those symptoms, and perhaps that's what alerted the dog?
It is possible. However, in this case, Mr. Harris had a methamphetamine lab in his car.
Would you say Aldo is an aggressive dog or rather tame?
He is a well-trained police dog who, in his tests, he has been trained for over 40 hours. According to the Scientific Working Group on Dog and Orthogonal Detector Guidelines, which is a partnership of law enforcement and other agencies who develop best practices for dog training.
May I continue?
If a dog alerts in the field, it doesn't mean that drugs aren't there. It just means that the drugs were there, but may not be there in the future. Only the controlled setting offers for sure whether drugs are present at the scene because the police planted them there themselves. So we would urge you not to take into account field tests of dogs' accuracy because they are not reliable because the police have no way of determining for sure whether drugs were there. Aldo is a well-trained dog. The dogs in the state of Florida are all well-trained before they are allowed to be used in the field. And passing their tests in controlled settings is the best way to determine whether they should be allowed. Requiring police officers to do field reports does not enhance the ability of police officers to detect drugs, nor does it offer a greater degree of privacy for the individuals because they will have to be searched by more intrusive means. For example, touching the individual or touching the car to begin with, rather than simply having the dog sniff at a reasonable distance from the car.
Okay, thank you, ma'am. Is the attorney for the defense ready? You may approach the podium, sir.
Thank you very much. Good morning. May it please the court. My name is Brian Keith Jackson, and I represent the defendant in this matter, Mr. Harris, in the case of Florida versus Harris. Counsel for the state is correct. The facts of this case are not at issue. My client was arrested following a routine traffic stop for the production of methamphetamines that were discovered in his car. Counsel for the state of Florida will have you believe this case is really about keeping records regarding dog searches. In reality, what this case focuses on is the fact that the state of Florida has violated my client's constitutional Fourth Amendment rights. The issue in this case is whether a false positive dog sniff gives the state of Florida police officers the constitutional right to search the inside of a car. My client was stopped for a routine traffic stop. What should have happened is my client should have been given a ticket and been allowed to proceed. But no, that's not what happened in this case. In this case, the Florida police went back to the vehicle after giving him a ticket, brought the dog out, and began sniffing around his car. Based upon a false positive drug test, the state of Florida contends that they now have probable cause to search the interior of the car, in which they did find materials designed to make methamphetamine.
Were these materials in plain view of the car?
The materials some of them were in plain view on the floor of the vehicle, some of them were in the back seat, some of them were in the trunk. But that is not the issue. The issue is whether or not the state of Florida Police Department has the constitutional right to search the inside of the car without probable cause and without a search warrant. There is no doubt in this matter that there was no search warrant. So the only thing we're arguing about is whether or not the police had probable cause to search the interior of the vehicle.
Well, with the plain view, with some of the drug-making material in plain view, in conjunction with your client's behavior, would that not have alerted then a search?
We would contend the answer is no, and here's the reason why. Anytime any officer stops someone on a public road and asks for a license identification, well, of course, the officer has a badge and a gun, and it's understandable why someone could appear to be nervous. That does not indicate criminal activity. It just means that the person has a badge and a gun and has stopped you on a public road when you weren't expecting it.
But along with the drug paraphernalia or the drugs or what, you've been very vague about what they found on the floor of his car that was in plain view.
Well, Your Honor,
in conjunction with that.
Yes, I will tell you what was found. What was found was muriatic acid. What was found was syringes. What was found was tubing. What was found was pseudoephedrine, all of which, Your Honor, are legal to possess.
Was your client a diabetic?
No, my client was not.
What gauge were those needles?
I'm uncertain I'm uncertain the answer to that question, Your Honor.
Was it a Vacutane or was it a syringe type?
There were syringe types, Your Honor. But again, all of that is irrelevant to your analysis.
How much rubber tubing?
I'm sorry?
How much rubber tubing?
I don't know the precise length of the rubber tubing. But again, all of that is irrelevant. It is not illegal to possess rubber tubing. It is not illegal to possess Tylenol flu and cold medicine. It is not illegal to possess muriatic acid.
What is the law in the state of Florida regarding how much methamphetamine one can possess? Because state by state...
There was no methamphetamine possessed, Your Honor. It was only the materials used. Pseudoephedrine.
What's the local law then in Florida for that county?
I'm uncertain what the local law is.
Was it not? What did they say? You know, how in some states you have to keep the drugs behind the counter.
That is correct, and that's
you
also.
You can only possess maybe 12 pills at a time. How many were there on the floor?
That is correct, but again, the only way that the officer was able to count the number of pills was following the intrusive interior search of the car.
But you said there were some in plain view.
But
how many were in plain view?
That is undetermined, Your Honor. But again, the reason for the state of Florida obtaining probable cause to search the interior of the car was based upon a false positive drug sniffing search by the dog. And we would contend that because the drug sniffing dog is unreliable, the state of Florida cannot use that sniff to justify their obtaining probable cause to search the interior of the car. We're not arguing that you should overturn your precedent, United States v. Place and Illinois v. Cabela's, in which you said the drug-sniffing dog is not even a search. The drug-sniffing dog can search the exterior of the car. That's not the issue. The issue is whether or not the false positive regarding the interior of the car gives the state of Florida Police Department the right to search the interior of the car, and we would say that it would not. Otherwise, what you would have is a situation where any dog at any time who says yes could violate everyone's constitutional rights and search the interior of anything on a public roadway. That is beyond.
It sounds to me that there was enough evidence and in plain view for the officer to request that the person steps out of the car and to do a search that would be legal because of what was in plain view. And that the dog wasn't really necessary.
And if the dog wasn't really necessary, then there would have been no reason for the police officer to go back to his car to retrieve the dog when he had already gave my client a ticket for the expired tag. So the Florida Police Department himself, at the moment, didn't believe he had enough probable cause to search the interior. Otherwise, he would have done so without the need of going back to his vehicle to retrieve the dog. So at least at that moment, Your Honor, the police department did not feel that they had probable cause to search the interior of the car, and that was the reason why they went back to get the dog. The dog sniffed false positive. Because the dog sniffed false positive, he cannot use that as a rationale for searching the interior of the car. If he believed they had probable cause beforehand, there would never been a need for him to go back to the car in the first place. Because he did, he believed he did not have probable cause. And as a result, he has violated my client's Fourth Amendment constitutional rights from being free from unreasonable search and seizure. And so what we want, Your Honor, is, in conclusion, the court should rule that, at least in this case, the Florida police actions were unconstitutional, and a charge against my client should be dropped for violation of his Fourth Amendment rights. Thank you.
Okay, thank you, sir. Would you like a rebuttal?
Yes.
The state. Yes, please.
The lawyer for Harris is correct that the only issue here is whether the search by the dog was legal. However, he is incorrect in his understanding of the Fourth Amendment. Remember, they only need a reasonable suspicion in order to search the car. The dog's indication was reasonable suspicion enough to allow them to search the car. Indeed, the lawyer for Harris has also not responded that field tests of the dog are inaccurate and contravene the best practices indicated by the organization which trains the working dogs. Aldo was doing a good job in this case. He did not find marijuana in the car, perhaps because Mr. Harris had recently finished consuming the marijuana in the car. The only way we can know if Aldo was correct or false positive was through lab tests, which he passed with excellence. Aldo is a well-trained dog and should be allowed to continue his search or his ability to investigate the scene. Finally, keep in mind that Aldo's participation is not a search. Nothing he did indicated a search of the car. The reason that there was probable cause to search the car was because Aldo indicated that illegal material was inside. If he did not have illegal material inside, we would not be here. Mr. Harris did. You should rule on behalf of the state of Florida.
Thank you.